When Roe versus Wade was overturned Friday, a number of states had abortion bans ready to take effect. Trigger laws in 13 states banned abortion immediately or soon after Roe was repealed, meaning the federal ruling triggers a state law banning abortion to go into effect. Some states are already seeing legal challenges to their trigger laws, and there are more lawsuits likely to follow. Joining us now for more is Greer Donley, an assistant professor at the University of Pittsburgh Law School and an expert on reproductive law. And Professor Donley, we appreciate your joining us. What is happening now across the country in terms of these trigger laws?
Yeah, so I mean, once the Supreme Court overturned Roe versus Wade, our system, which had a national right to abortion, all of a sudden was now a patchwork of state-by-state laws. So as you mentioned, 13 states have trigger laws that were on the books. It's worth noting that every state's trigger law is different. In general, there are 3 different types of trigger laws. So there are some trigger laws that took effect immediately. There are some trigger laws that are supposed to take effect in 30 days. And then there are another group of trigger laws that take effect after some sort of a procedural action by a governor, by some sort of state official. And so right now it looks like roughly 9 states have already have abortion bans that are being enforced in just the past few days.
It is noticeable how those states are contiguous as we look at the map there. Professor, today a judge in Louisiana temporarily blocked enforcement of that state's trigger law. What are you looking for as that legal battle escalates and perhaps goes national?
Yeah, I mean, again, so every state is going to be their own, or going to have their own battles to look forward to. So the types of laws and the types of legal challenges we're starting to see are varied across state, and that's based on the state's own law. So some of the challenges are based on the state constitutional provision. So you see some of these challenges saying, hey, the state constitution in this particular state actually protects the right to abortion. So even though the federal constitution doesn't, the state constitution does. There have been many states that have actually found that their state constitution protects this right. So that's one of the theories that people are pursuing in this new world. But you also have litigants who are saying that these laws are unconstitutionally vague, or that, you know, in some cases you have states that are trying to enforce them before perhaps the time has happened for the trigger law. So in Texas, for instance, it's not supposed to take effect until 30 days, but there are some people saying that it's taking effect now. So you have a variety of different challenges that are happening across the country that are really based on what the parties think are the best legal strategies for that state.
Well, what about the states that banned abortion before Roe versus Wade, before the 1970s? What happens in those states?
Yeah, so again, this is just kind of the theme, right? It's all going back to the states. So the pre-Roe bans, and there were about 9 states that had pre-Roe bans on the books, they also fit into different categories. So in some states, you have pre-Roe bans on the books that had been enjoined by a court. So a court had previously said, because of Roe versus Wade, you cannot enforce this statute anymore. In that case, you know, the pre-Roe laws are not going to just immediately come back to life. They're going to have to go back to court and get a court to lift that injunction. In other places, there is no injunction, right? The state officials just stopped enforcing the ban. So in those states, theoretically, they could come back to life. But again, that is something that's going to be litigated as well. Can a law that's over 50 years old, just that has been, you know, deemed unconstitutional for so long, come back to life immediately? And we'll see those battles play out. Sorry.
We see new battles coming, too, that are about to play out. We saw South Dakota's governor, Kristi Noem, say yesterday she plans on banning mail-order abortion pills. Are there any challenges for her state doing that legally or constitutionally?
Yes. So, you know, abortion pills are definitely the future of abortion access in this country. So, you know, historically, abortion provision used to happen by a procedure, but the most recent data we have suggests that the majority of abortions in this country actually happen by pills now. So medication abortion is a 2-drug regimen that can be used up through 10 weeks of pregnancy to safely end a pregnancy. Medication abortion really opens up doors for abortion access, because it can be sent through the mail, it can be obtained via telehealth, and you have organizations like Aid Access and Plan C that are helping folks access medication abortion even in states where it might be banned. So certainly the anti-abortion movement knows that this is one of the existential crises that it'll be facing in the future, and it is looking for every opportunity it can to try to ban pills from coming into their state. But, the battle's on both sides. So there's arguments from the abortion rights perspective as well, that actually medication abortion, because it's regulated by the FDA, the federal government controls it, the states do not. So we're going to see, again, a lot of kind of conflicts coming up between the federal government and the state government, and states trying to see how they can control the pills from entering their state borders.
Greer Donley, a lot to corral this week. We appreciate you giving us time and giving us your expertise.
Thank you.